The Supreme Court is now in session. The Honorable
Chief Justice, she has to start recording. Shelter. It's streaming live, but you have to do the recording itself.
Thank you, Doris.
The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice presiding. This is Supreme Court case WRP21-001. Government of Guam petitioner versus Superior Court of Guam respondent. Teleguam Holdings, Inc., real party in interest, and Teleguam Holdings, LLC, non-party claiming interest. Appearing for petitioner is attorney Jordan Lawrence Pauloon. Appearing for respondent Teleguam Holdings is attorney Anita P. Areola. Appearing for respondent Superior Court of Guam is attorney Daniel F. Menching. Attorney Pauloon reserves 10 minutes. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman.
Thank you, Madam Clerk. At this time, Assistant Attorney General Pauloon, you are recognized.
Thank you, Mr. Chief Justice, and may it please the court. My name is Jordan Pauloon, and I represent the government of Guam. The government seeks writs of prohibition and review, or alternatively interlocutory review in this case. The government filed a straightforward civil enforcement action under the Deceptive Trade Practices Act against Teleguam Holdings Incorporated, alleging violations because it passed on the 2018 business privilege tax increase to its customers as a separate line item addition in a manner this court disapproved of in both Guam versus Marfega Trading Company and Kitchicho versus Macy's. But now, instead of being allowed to prosecute its case, a non-party, Teleguam Holdings LLC, has shown up and created a mess in innumerable ways. This mess includes things such as filing an answer to a lawsuit in which it wasn't sued, asserting a bad faith counterclaim without ever seeking to intervene or become a party, engaging in what the case law refers to as the harassing practice of deposing opposing counsel. And after the Superior Court inexplicably refused to issue a protective order, the LLC far exceeded the scope of the depositions it represented it would take, seeking information protected by work product privilege instead. And finally, it sought disqualification of an assistant attorney general on palpably unreasonable grounds, claiming that opposing counsel is a necessary witness.
So on that issue, Mr. Pauloon, in reference to disqualification, as you pointed out in your 13I letter, that now that Mr. Pahokee has Assistant Attorney General has resigned, that is no longer, I understand that's no longer an issue in the case, but you still maintain that the second issue, as you have outlined in your petition, continues to be at issue in the case. And so what other remedy are you seeking in reference to the disqualification that makes it such that the second issue, as you've outlined, is not moved?
So there are two principal issues with the Superior Court's disqualification order. One, it failed to address the threshold questions of standing and jurisdiction and sovereign immunity. Second is the disqualification of Assistant Attorney General Pahokee. That's not moot because in this case, for several reasons, but primarily in this case, the LLC has asserted that Mr. Pahokee is a necessary witness. And that is a finding that was accepted in the disqualification order. And the LLC still, by all indications, intends to call him as a witness at trial. That finding alone is not mooted by his departure because they still seek to call him and invade and continue a further deposition of him. They also have a pending sanctions motion against it, as well as they want to call him as a witness at trial.
But just first in particular, in reference to the disqualification order of Mr. Pahokee, that you agree that's a moot issue. I mean, there's no remedy that we can provide that if we were to grant your writ that and reverse the trial court in the disqualification order, that Mr. Pahokee can now act as an attorney for the government. that you agree, that is a moot point.
The actual disqualification of him to continue as an attorney is largely obviated by his departure, but I don't think that moots the analysis of the disqualification order itself. This court should review the disqualification order also because the next attorneys that will be on this case will be subject to this same line of disqualification for investigating.
I think there's a big disagreement there, as Mr. Menching pointed out, for the Superior Court. Mr. Pahokee decided to undertake this investigation, at least from what the trial court is saying in its decision and order, where he acted as the investigator and the lawyer. And as a result of how he conducted himself, he has subjected himself, whether we agree with it or not, he has subjected himself in reference to being the only person with certain facts, as the trial court has pointed out, and that therefore the trial court decided that he agrees that he's a necessary witness in the case. I don't know necessarily if that is the same with all the other attorneys that are remaining, that they actually are the ones who conducted the investigation and therefore is subject, to these depositions. But to me, it appears that it's the nature in which Mr. Pahokee undertook the investigation of this case that subjected himself to this position in the eyes of the trial court.
And I think that's fundamentally the legal error that the trial court committed. Attorneys are not witnesses for doing things that attorneys are ethically and professionally obligated to do. If you actually look at the Superior Court's disqualification order, it cited 4 things that were disqualifying: that he investigated the case, that he issued civil investigative demands, that he signed answers to interrogatories and objections, as well as talking to third-party witnesses. Every attorney has to do all of those things in the ordinary course of litigation. Civil investigative demands are essentially an equivalent of a subpoena.
Well, I don't think that's quite the extreme that the trial court, at least not the way I observe how the trial court is describing it. I think the trial court is suggesting that if you're going to investigate certain facts, that's why you have investigators. That's why the Office of the Attorney General has investigators to investigate these facts. And then based on the review of the facts, then the lawyer will examine the law and decide how to proceed and do its duties under our rules that require it to sign certain pleadings. But I'm not necessarily understanding the trial court to say that all lawyers who decide to sign pleadings are now going to be disqualified in this particular case. I think the court was making a point is the way that this particular lawyer undertook to investigate and decide, based on similar issues with a competitor of GTA, that he has subjected himself into this position. And I don't think that's such an unreasonable position to take.
But I'm hard pressed in the Superior Court's order to find what those facts are beyond simple investigation done as an attorney. And this is also why it also particularly impacts the government in a case like this, because the government is given prosecutorial powers in a way that private attorneys generally aren't. We have a statutory ability to issue a pre-suit subpoena or civil investigative demand, which we did in this case, to get documents to investigate violations.
How are we in a better position to examine those facts if you even disagree with the trial court on the basis of its disqualification doing investigative actions? How are we in the Supreme Court now going to determine what just the length, the extent of the lawyer's investigative role here that you say is just pretty common in reference to how lawyers examine cases and decide in terms of how to proceed?
So first of all, I'll reference this court's GRAP Rule 21.1 and Civil Rule of Procedure 11 that actually puts an investigative duty on attorneys before filing their own cases, that they have to actually investigate and examine these things. But second of all, no one from our side is actually disagreeing with the four thing that Mr. Paholke did, those four things, that he investigated the case, issued civil investigative demands.
That was going to be my question. I mean, my understanding is the government doesn't dispute that he engaged in these activities that the trial court found transformed him from an attorney to a necessary witness. Your question is whether, as a matter of law, that is required.
That is correct, that those are just not, as a matter of law, disqualifying activities. Because also, if you look at the rules that he was disqualified under, which are 3.7 and 1.7, it's the 1.7 deals with actual conflicts of interest with a present client, and 3.7 deals with acting as an advocate at a trial. Under 1.7, the only personal interest that Mr. Paholke had that was referenced by the trial court was his character and reputation as an attorney. The logical implication of that is anytime a case is filed, all you have to do is claim that it was filed in bad faith, and the other opposing counsel is automatically disqualified because every attorney has an interest in their reputation.
Does this suggest, I mean, Teleguam's attorney suggests that investigators are the ones responsible for investigating as the Chief Justice, but Mr. Paholke investigated this case by himself, and because of that, he ended up being both a witness and a participant in the factual events. Does this dictate that in every single case, if that is the situation, that an investigator must be used and an attorney cannot investigate a case, or even if it's a run-of-the-mill case, potentially?
That would be the logical conclusion of the Superior Court's order, yes. And in this, and there are plenty of cases that I've even tried where I have to go out and talk with witnesses, collect the evidence, and marshal the facts that I need to present my case. Investigators do certain activities, but also when it comes to civil investigative demands, for example, lawyers are the ones that are much more well-positioned to flush out what belongs in a civil investigative demand or a subpoena and request those documents from an opposing party or during an investigation.
Mr. Paulon, the distinction that I'm seeing here is that the court has made it particularly clear that Mr. Paholke is the only source in which this information is derived from, that can be examined. Mr. Paholke is the only source. In your case, where you go out and you independently verify certain facts, and in order to properly bring a pleading before the court, that's all understandable. But if in a particular contentious case where there are certain civil actions being taken, and the basis for those civil actions, the lawyer is the only person that gleans those facts, I think that's a little different.
Mr. Paholke is not the holder of the facts that are relevant to this case. The central question in this case, in the case that was filed, was whether GTA's conduct in passing on the business privilege tax to its customers as a separate additional line item violated the Deceptive Trade Practices Act. There's no allegation that Mr. Paholke was involved in that decision-making process. All he did was investigate that after the fact and collect documents from GTA. He's also not the only source of information here, because if you go through the case and you go through the nature of how these work, the Attorney General's office collects information from third parties. There is a source of that information as well, and that is the third party.
What about the contention of Attorney Areola that Mr. Paholke discussed the matter allegedly with a competitor of GTA, and a competitor of GTA did the very same thing, but they didn't seem to be put in the same position in reference. So aren't those allegations of interest in reference to GTA's desire to try and determine why is it that it is being treated differently from a competitor who, according to GTA, and we're not accepting that, this is necessarily the truth, that these are allegations that it wishes to examine so that it can properly defend itself.
So there are 2 points on this. First, the allegation that he talked with third parties from the competitor is because the competitor was the one who had actually filed one of the consumer complaints. What it was discovered too, one of their employees was also the filer of the other consumer complaint. But in the standard practice of how you handle consumer complaints, you get them in, sometimes you contact them, sometimes they'll contact you first, but in investigating a case, you have to contact the complainant themselves, and the competitor was the complainant. Additionally, any of the information held by the competitor or those conversations is discoverable from the individuals that signed and filed the complaints, and we even had depositions of those individuals in this case. So to say that Mr. Pahokee is the only source of those conversations is just not supported by the nature of how conversations and investigations work. We're collecting information from third parties. The other thing with Docomo's complaints too, that was the competitor that had filed the complaint. There was an evidence submitted in one of the depositions that demonstrates that they actually had refunded money. So they're not similarly situated, but whether they're similarly situated or not, we can accept the allegations as true, but there's relatively clear case law that you don't have standing to complain about the non-prosecution of a third party. It does, just because somebody else has broken the law doesn't mean that you're allowed to persist in that action.
That can very well be the case, but I mean, the allegation is this is harassment. That's the assertion that, one of the things that Attorney Arriola has raised, that this constitutes harassment of her client. If in fact there are similarly situated competitors, and that one is being treated differently than the other.
So the primary evidence of harassment that's been cited by the LLC here is that Mr. Pahokee issued burdensome civil investigative demands. The LLC, though, through three civil investigative demands, and then there was a fourth issued to the incorporated, to which the LLC responded. But through the civil investigative demand process, the LLC participated, responded to those, and did not avail themselves of the statutory process for actually objecting to a civil investigative demand. If you don't object to a civil investigative demand during the statutory window to seek review with the Superior Court of the demand itself, those objections are waived. So to now say, after that process is over, that this constitutes harassment is just an 11th hour switch to try and avoid liability.
So I'm going to go back. I'm going to go back to my question in reference to whether or not the issuance of the disqualification order in light of Mr. Pahokee's resignation is moot. And your response is yes, but all the other lawyers in the Assistant Attorney General's office will be in the same position. But that's rather speculative in my mind, as it's because, number one, the trial judge has not issued an order disqualifying the entire Attorney General's office, because it's conducting the similar activities as Mr. Pahokee. So I'm just wanting, again, clarification. Is that the only other reason why you feel that the issue number 2 is not moot?
No, that is not. The issue is not moot. I do think that this court's vacating of the order would not remedy could not give a remedy of putting him back on the case now that he's left. But there are other implications of the order, including him as a necessary witness to be called at trial that was found there, that inflict a specific injury against the government and its work product. So on the other bases of it, it's not moot. The other thing too is taking—
But before you go on very quickly with that, and you're maintaining that Attorney Areola will be seeking the work product of Attorney Pahokee. Again, number one, there are measures that can be taken in the first instance before the trial court, should there be specific instances of that, without us engaging in that based on assertions and not actual controversies, where there is a specific document that is being sought that is the work product of a lawyer that otherwise would be protected. To me, in the first instance, that should be brought before the trial judge.
And that was brought before the trial judge, and the protective order over the depositions was denied. And those depositions that were permitted to go forward are actually a basis of the disqualification in the disqualification order. They're referenced in there. And so that continuing impact of this order is not rendered, means that the issue is not moot. Even if this court, though, finds that it's moot and wants to have the superior court review some of these things in the first instance, the way out of that too is to still vacate the order as moot, because it's become moot while pending in this court, and remand for further proceedings under the Munsingware doctrine. However, one of the other specific issues with this order and the continuing proceedings below is that the Superior Court has refused to engage in analysis of the government's sovereign immunity claim, refusing to hear from the government, even at the hearings that have been put up for this court's, the transcripts of which are included in the judicial review, Let
me just say as to that, Attorney Pawloon, because the government, the Superior Court has filed a pleading that takes issue with that, and that the Superior Court pretty much says that the Attorney General's office just jumped the gun on this. I mean, there are pending motions in which the motion to drop a party and to add a proper party that has been fully briefed, that's pending, and the only reason the court hasn't decided this is because it decided, for whatever reason, whether we agree with it or not, on the disqualification issue first. And in terms of the sovereign immunity issue, there's a motion to dismiss filed by the government in which, in the first instance, the trial court will address, now that it has decided, the disqualification issue, and whether we agree that rules of professional responsibility 3.7 or 1.7 is implicated here. That's the decision of the trial court in handling what seemingly is a complex procedural posture of the case.
I think one of the fundamental problems, though, too, is granting the motion to disqualify without hearing these things is because it's brought by a non-party. The LLC's only interest in this is their putative counterclaim. And that counterclaim is what is primarily asserted to need Mr. Pahokee as a witness. So sovereign immunity, yes, that claim should be decided first.
If you are correct, Mr. Pawloon, that in fact, that sovereign immunity is implicated and that the LLC has no standing in the case. If you are correct and the trial court decides that, then its order of disqualification is void ab initio because it had no jurisdiction. And so I don't see why this can't all play out in the trial court in reference to matters that are continuing to be pending. It just seems to me that there are adequate remedies of law, and issuing a writ is a tall order here.
And just as a follow-up to that, I mean, the fact that the trial court took the order of the suspension or the disqualification of the lawyer first, I don't think necessarily prevents the trial court from examining the sovereign immunity issue, of course. And there might have been a reason why they felt that the misconduct could have tainted the proceeding and impair the fair and efficient administration of justice. So if they went forward with that first, but then ultimately addressed the sovereign immunity and the other issue of standing, then it seems like you have a remedy available to you, and that is the trial court examining that.
Part of the issue with that is Mr. Paholke was the one who drafted and filed and was prepared to argue the motion to dismiss. That was turned away because he was under a threat of disqualification from a non-party.
But let's look at this hypothetical, Mr. Paulun. What if an attorney who was actually suspended or disbarred came to appear before the court and said, I want to argue a sovereign immunity issue? You think the court has to be complicit and let that attorney proceed with arguing that issue? I don't think so.
No,
So
but
the court has an interest in ensuring that the attorney's participation doesn't taint the proceeding and impair the efficient administration of justice.
I agree in that case, because the person appearing would not be an attorney in that case. But if you look at 3.7, the primary rule for disqualification here, it applies to being an advocate at a trial, which the case law is pretty clear does not reach pretrial activities unless they're going to disclose the interest during the trial. Additionally, under the Deceptive Trade Practices Act, it's a bench trial in which the trial court stands no risk of confusion under the case law and literature. I would like to reserve the remainder of my time, but we believe that the interest in this going forward and for work product, as well as this being done at requests of a non-party for which there's no jurisdiction, and this is the first order entered in this case inflicting this type of harm against the government's sovereign immunity interests, warrant a writ of prohibition or review, or alternatively interlocutory review. Thank you.
Thank you, Mr. Paulun. Attorney Arreola, you are recognized.
Mr. Chief Justice, may it please the court. It is not the purpose of a writ of prohibition or a writ of review to correct petitioners' failures or mistakes that were made in the trial court. Yet that is what they are asking.
Excuse me, Ms. Arreola, I'm getting some kind of feedback. Could you please check your sound? Okay, thank you.
Do you still hear the feedback now?
Apparently the others don't, so that's fine. Go ahead.
Okay. The petitioners never raised Teleguam Holdings LLC lack of standing in their motion to dismiss. They never raised LLC's lack of standing in the motion to disqualify. It was not until 10 months into the case, 13 depositions, and numerous pretrial motions later that petitioners raised LLC's lack of standing in October 2021. When they finally did raise it and it was fully briefed, they refused to wait for the trial court to address the issue and instead filed their petition here. They also seek an interlocutory appeal asking this court to intervene and dictate the order in which the trial court addresses the issues in this case. But under the recent Cortec decision, this court would overstep its jurisdiction if it did so. We submit that the court should reject the petition in its entirety. We begin with the fact that the disqualification order is moot. Petitioners are seeking to reverse the disqualification order to prevent Mr. Paholke from being a necessary witness. Alternatively, they ask that Mr. Paholke not be disqualified from serving as trial counsel. The order is moot because those issues are no longer at issue.
What about the argument that his strategy and work product would be discoverable as a result of his disqualification?
Your Honor, his deposition was already taken. That horse has left the barn. You know, they never came to this court seeking a petition for a writ to prevent the deposition from going forward. Because his deposition has already been taken, his testimony is admissible as is any other deposition testimony in the case. And they did not prevent the deposition from going forward. They also did not.
Well, you also did the deposition of Mr. Nishihara, who's being advanced as alternative counsel in this case. and you seem to recognize that he's also available to take this case to trial. Does that also then create the same problems for him so that the matter is not moot, as Mr. Pauloon indicates?
Not necessarily. The main argument that Mr. Pauloon is arguing is that the next attorneys who will take on this case will be subject to depositions, and that's not true. The only person who we believe is a critical and necessary witness in this case is Mr. Paholke. And it's not because he did mere investigations as an assistant attorney general. The primary reason that he is a witness in this case is because he had direct communications with James Hoffman from Docomo. Not only a competitor, but a company that filed a consumer complaint in this case against GTA. Mr. Paholke took the deposition of Joseph Shinohara from GTA in his investigation of GTA. He did not depose Mr. Hoffman when he could have. It is his direct communications with Mr. Hoffman that are at issue here. Why? Because it was after those communications that Docomo filed a consumer complaint against GTA. We don't believe that that was coincidental. And Mr. Paholke testified in his deposition that he relied upon the Docomo consumer complaint in filing this action against GTA.
The Assistant Attorney General points out that the trial court found the 4 matters it made that Paholke did that warranted disqualification. And he pointed out that those 4 matters were that he drafted and verified the objections and answers to interrogatories, authored and sent civil investigative demands, demanded documents from GTA, and communicated with third-party witnesses, presumably in this case, Mr. Hoffman from Docomo. Doesn't the Attorney General, are you suggesting that the Attorney General has to have an investigator do that work as opposed to an Assistant Attorney General?
That's the policy of the Attorney General's office. Mr. Paholke violated that policy. That is clear from the depositions of the investigators. And Mr. Paholke testified—
But is it mandatory in all cases?
Not necessarily mandatory, Your Honor, but it is important for an Assistant Attorney General in order to prevent them from becoming witnesses in the case. The issue here is not that Mr. Paholke conducted investigations. It is that he directly insinuated himself into this case and learned information that only he has and that's unobtainable elsewhere. At the hearing on the
does it make a difference that counsel in a particular case is acting in both their representative and a substantive manner? I mean, in this case, they brought the action, obviously, in the government of Guam, but under the statute, the Attorney General is responsible for bringing civil investigations and undertaking this. So, I mean, it's not like the governor's his client. It's not like another agency's his client in this case. So they seem to be acting in both the representative and substantive decision-making in this case. Does that make a difference?
No, it doesn't make a difference because Rule 3.7 is clear. If you are likely, not if you are a necessary witness, if you are likely to be a necessary witness, you're going to be disqualified. You need to be careful about your investigations. At the hearing on the motion to disqualify, the trial judge asked repeatedly, who else is going to get testimony? And who else is going to give testimony in favor of the petitioner? There was no answer. They couldn't say the investigators, they couldn't say another attorney, they couldn't say another witness. The only person that has this information is Mr. Paholke. That's why he became a likely and a necessary witness in this case. But
why couldn't they get that information from Mr. Hoffman, as Assistant Attorney General Pauloon suggests?
Because the credibility of both witnesses is at issue. Because Mr. Hoffman testified that when he filed the consumer complaint, he didn't hit his statements in the consumer complaint are incorrect or untrue. Did Mr. Paholke ever investigate that consumer complaint? No, he did not. And so there's a credibility issue between both of them, which again makes Mr. Paholke a necessary witness because he had direct communications with Mr. Hoffman, and it's only the two of them and their word against each other.
But isn't this going to make it more difficult for the Attorney General's office to investigate consumer complaints?
Not at all. Follow your policy. The policy is when a consumer complaint, and this is what the investigators testified, when the consumer complaint comes into your office, we farm it out to the lawyer assigns an investigator to investigate that case. Mr. Puhalki did not do that. The investigators stated very clearly in their depositions, we were not assigned, we did not investigate the case, we did not do anything in this case.
The statute seems to vest the Attorney General with responsibility for investigating violations of the consumer protection law. How do we reconcile the specific functions that are set forth in the statute with the argument that they should not be investigating?
My argument today here, Your Honor, is not that they should not be investigating, but the statute is very clear what tools are available to the attorney generals. And that is they can depose witnesses, they can subpoena witnesses, they can issue civil investigative demands, much like interrogatories and requests for production of documents. Mr. Puhalki did not depose anyone from Docomo. He did not depose Mr. Hoffman, and he did not depose the other consumer complainant, Frank Cruz. He did depose Mr. Shinohara from GTA. So he knows what the tools are, and he knew what they were when he was investigating this case. He should have used the tools that are stated specifically in the statute, and he did not do that. The question here is there anything left for this court to decide? There is nothing left. The court need not decide the issue regarding the disqualification order because it's now moot. They are not suffering irreparable harm because the attorney generals will now face the prospect of being disqualified for merely investigating their cases because Mr. Puhalki did something that most other attorney generals never ever do. They don't insert themselves into a case. They don't become the chief witness and the chief communicant with another person about what the facts are of a particular case.
What about the argument raised by the Assistant Attorney General that that vacating the order, if this is a situation, and then remanding for further proceedings in light of the fact that it's moot?
What would that further proceedings do? He hasn't specified that. I'm not sure what the point is of vacating a disqualification order, remanding it for further proceedings to do what? They waived the issues concerning Mr. Puhalki's deposition. It's admissible now in court and in trial. They waived the issues regarding questions relating to the attorney work product privilege because they didn't halt the deposition and request a protective order and put a halt to the deposition. His deposition testimony is now admissible. They didn't follow the rules. And so what else is to be done? We submit that there's no irreparable injury, and that's the only reason for this court to issue a writ of prohibition or a writ of review. There is an adequate remedy at law with an appeal after final judgment on the merits of the case. All of these facts demonstrate that this is a fact-specific disqualification order, and there is no reasonable expectation that the Attorney General's office will be subject to the same issue. The disqualification order is moot. If this court determines to address the standing issue, it will, as it's stated in the Cortec decision, overstep its jurisdiction. That's because this issue has been fully briefed in the trial court, and the trial court should get first shot at determining this issue. If every single time a litigant fails to raise issues in court, jumps the gun and decides to come here to this court and says, cries foul and says, they have no standing, when they didn't raise it in the trial court in a timely manner, then this court is opening itself up to all manner of cases, all manner of petitions for writ of prohibition, writ of review, and interlocutory appeal, and that's not the function of this court. The merits of this case concern who assessed the business privilege tax increase on its customer and who allegedly failed to give notice to its customers about the BPT increase. While Inc. was named in the caption, that party is Teleguam Holdings, LLC. The trial court did not exceed its jurisdiction in deciding the disqualification motion because LLC is a proper party defendant in the case. Paragraph 5 of the complaint identifies the defendant as a foreign limited liability company. All of the allegations in the
But Attorney Ariola, that is, number one, it's not an issue before us. Number two, that remains to be decided by the trial court. So
correct, Your Honor.
you may contend that all you desire, but that's still a disputed issue, and that's pending before the trial court.
I agree with you, Your Honor. That's correct. And I think that's one of the issues that is so important to emphasize here in this case. We are now on a limited record before this court. All of the speculation about what the trial court did or didn't do, the order in which the trial court addressed certain issues, we're on a limited record in this petition. If the court waits until after there's an appeal, after a judgment in this issue, we will have a fully developed record in which to address all of these issues and not do it piecemeal as this court is doing, or as the Attorney General wants this court to do on this petition.
I just want to clarify something, Attorney Ariola. Attorney Pauloon, in arguing that the matter was not moot, that obviously Pahokee can't come back and be counsel of record in this proceeding, that vacating the order would still provide meaningful relief because it would address the strategy and work product issue of not being discoverable regardless of the disqualification order. But your position is that they have waived any objection based on attorney work product and trial strategy.
Yes, Your Honor, that is our position. And also it's a position that should be decided by the trial court if it comes up again. For example, if we go to trial and we want to use this deposition testimony and they raise that issue again, the trial court should decide that issue in the first instance, not this court. If the court does a preemptive strike and prevents us from using the deposition of Mr. Pahokee, or writes a decision that says we remand for further proceedings, but you can't use attorney work product privilege, that's preventing us from doing our job and from admitting the deposition testimony when it's clear that it's admissible.
What about the idea that the government doesn't dispute the facts of what Attorney Pahokee did, and whether those facts, the four things that the trial court found that he did that made him a necessary witness could be examined as a matter of law as to whether that warranted disqualification and therefore deserving of interlocutory review?
Again, a writ of prohibition and a writ of review is not there to correct their mistakes that they made in the trial court. They must show that they are without a plain, speedy, and adequate remedy at law.
No, this is on an interlocutory basis under the standards that we have set forth in 3108 for interlocutory review. They argue that this is a matter of importance for them, and they fit the test because it will clarify issues of general importance regarding the scope of the Attorney General's powers in a consumer protection case based on these facts that are there, and that it can materially advance the termination of the litigation because they'll address whether other attorneys might be subject to the same disqualification orders.
So everything that you've just said, Your Honor, is totally speculative, and that's not the purpose of an interlocutory appeal. In the recent Cortec decision, this court held that the burden to obtain interlocutory appellate relief is an exceptionally high burden, and the court does not overstep its jurisdiction if the trial court should address the issues in the first instance. This is not a question of law that will materially advance the termination of a litigation. How could it? It's just it's an order that the court would basically issue saying, well, we think or we don't think that the disqualification order was correctly decided. How could it do that on the record before it? And how could it clarify further proceedings in this case when the deposition is already taken, Mr. Pahokee is a witness, and it's very clear that he's going to be called as a witness in the case? What the Attorney General's office is asking this court to do is to speculate about what could happen in the future. That's not the reason, and that's not the purpose of an interlocutory appeal. And this is not an issue of general importance in the administration of justice. This is a fact-specific disqualification order, as most disqualification orders are. It would not clarify issues of general importance because it relates solely to what happened in this case. And finally, it's not going to advance the termination of litigation because it's not an issue in which it's going to terminate the litigation or terminate any issue in the litigation. The disqualification order is moot, as we have stated before. In terms of the sovereign immunity issue, Your Honor, this is one of the most puzzling issues in this case to me, because the court was ready to proceed on the motion to dismiss. We mentioned that we were going to file a motion for disqualification, and the Office of the Attorney General, Mr. Perez, stated, I'm not ready to proceed. Can we please, delay it? And the court said, okay, we're going to delay it until after the disqualification motion is decided. Then they run to this court and say, it's so important. Sovereign immunity is so important. This court should address it. Well, why didn't they argue it back then? And why didn't they move for a stay of discovery concerning the sovereign immunity and the counterclaim? They did not. Again, this is a case where a writ of prohibition and a writ of review is not to remedy the Attorney General's mistakes in the case. They didn't take the appropriate steps. They didn't take the appropriate actions to preserve their issues, and instead ran to this court thinking, maybe we can get some relief in this court. The court should decline their invitation to do that, because that is not the role of this court, and the trial court should address these issues in the first instance, as is its job. One of the issues that I wanted to address is something having to do with the Barrett-Anderson decision and the fact that the Attorney General's office is relying on that decision heavily for the proposition that Rule 1.7 does not cover an attorney's pro se activities. They argue that the key question in that case is who ultimately controls the litigation. I have searched in vain in that decision for that principle of law or that conclusion, and that principle is not there. And in fact, their statement of the principle of law is contrary to Barrett-Anderson 1, the 2015 decision in which this case held that standing concerns a party's relationship to a dispute, not an attorney's. In addition, there are two rules here that we relied upon for disqualification of Mr. Paholke: Rule 3.7 as a necessary witness and Rule 1.7. Neither of those rules were at issue in Barrett-Anderson 1 or Barrett-Anderson 2. And so that case is not controlling in this case. Another issue that the Attorney General's office has brought up is that sovereign immunity and the disqualification issue had to do with the counterclaim. That's not what the disqualification order said. The disqualification order held that the disqualification was necessary here, not just as to GTA's counterclaims, but also to their affirmative defenses: failure to state a claim, waiver, estoppel, and laches. And so the petitioners in this case do not meet the requirements for a writ of prohibition, a writ of review, or an interlocutory appeal. Unless this court has any further questions.
I don't. Thank you, Attorney Ariola. And so you are.
Excuse me, may I ask?
Okay.
Yes,
Mary?
yes, Your Honor.
I just want to make sure I understand the facts. The motions that were prepared to dismiss and the sovereign immunity issue motions are still pending in the trial court. Has there been argument or any hearing since the writs were filed?
No, Your Honor, there have been no arguments and no hearings. That motion to dismiss was filed quite a long time ago during the summer of last year. The trial judge held it in abeyance until it could decide the disqualification motion. The disqualification motion was decided in December, and nothing has been held since then on the motion to dismiss.
Thank you.
It's still
That's my only question.
Thank you. Thank you, Attorney Ariola. Mr. Pauloon, you have 5 minutes remaining.
Thank you, Your Honor. Sovereign immunity is a jurisdictional matter that must be shown and addressed at every stage of a proceeding. The LLC showed up here without ever having standing to do so because it was never sued and asserted that it was the proper party. The trial court had the first shot to address this issue, but failed to even hear from the government at the motion to dismiss hearing because of the threat of disqualification. While the LLC asserts baldly that we refused to proceed at that hearing, the transcript of that hearing demonstrates otherwise. Mr. Paholke was ready to argue, and 3.7 does not prohibit his participation in arguing legal matters. Additionally, when Mr. Perez was asked, he indicated that he was not ready to argue, but was prepared to rest on the briefs. So the Superior Court could have taken our motion on the briefs at our suggestion and addressed the issue in the first as a preliminary matter as directed by Guam Police Department versus Superior Court Lujan. The order in this case is the first order that the Superior Court entered at the request of the non-party that inflicted the specific injury to sovereign immunity. The LLC further asserts that the government didn't follow the rules and failed to object to all of these things, but it was the LLC that failed to actually follow the proper procedures and failed to move to intervene, failed to file a motion to join a necessary party, but waited until late stages to file what is now a pending motion to add drop a party, which is not used for substantive decisions like this one. What happened here is that the party that was sued, Teleguam Holdings Incorporated, is the party that the government intended to sue and is still pressing forward, and they have failed to appear completely. So it is the government's position that the case should go forward against the incorporated. The whole discussion in the briefs and other things about misnomer is a misplaced reliance because the government gets to choose who it sues, not a defendant. I have actually, in my nearly 10 years of practice, I'm hard-pressed to find a case like this one where somebody persists in being a defendant, where the plaintiff repeatedly states, we didn't sue you. And I admit that some of these issues—
But can't the trial court address that and will address that? And they express that they are going to address that. So it doesn't seem like there's an irreparable, you have an adequate remedy at law available to you.
But when the Superior Court when those issues were presented to the Superior Court and including the sovereign immunity, the Superior Court refused to hear from us, even though the disqualification rules that it applied to all stages of the proceedings plainly by their own text only apply to trial. Additionally, at the motion to disqualify hearing, the court was again pressed to decide the motion to dismiss first, but then didn't, and I even argued that particular motion. And at that one, the court again refused to hear any pleas regarding the motion to dismiss based on sovereign immunity.
Well, your description, it sounds like it's very frustrating that the trial court is not proceeding in the manner that the government would like it in reference to how it should handle the disposition of the case. That's within the discretion of the trial court, and there's nothing in the record that I have read that says, I, Superior Court Judge so-and-so, I am not going to rule on this motion. So, next issue. It's from the pleading that's been filed by the Superior Court, it decided how it wishes to proceed in the procedural issues, but even there, it never said, I absolutely refuse to address the standing issue, the motion to drop a party and add a party. The description, you may be entirely correct that the proper motion should have been the motion to intervene, but be that as it may, the bottom line is the court is going to get at if it's given the opportunity, as I read the posture of the case, that it will get to that point, and so long as that is the case, you are engaging in a remedy that's still available to the government.
This is not available because the order entered at the request of a non-party exceeds the lower court's jurisdiction and inflicts specific injuries to sovereign immunity. This court's made it clear that that's something that should be addressed first.
But
and
you are correct when you pointed out the fire department case, that in that particular case, as you're quite aware, Mr. Palu, the facts of this case is that statute of limitations were implicated, and it was quite apparent that the statute of limitations would prohibit this claim from cause of action proceeding forward. And in our exercise of our discretion on those particular facts, we did not see that the government should have to go through defending the case before that issue is decided. Statute of limitations is not implicated here. There is a pending motion to drop and substitute a party, and the government has filed a motion to dismiss the counterclaim on the sovereign immunity issue. So you know, the case is quite different in reference to the posture of the case that is before us.
It's different in the sense that there is a different issue of jurisdiction, but the fact is a non-party showed up here, filed answers and counterclaims, which it had no standing to do, and then also asserts that Mr. Pahulke's testimony is relevant to affirmative defenses, which it can't even assert because it's not a defendant. There are pending motions for sanctions and depositions related to the testimony already given because there were significant unresolved work product objections. And in this case—
Isn't that just you stating that? Isn't there an adequate remedy at law that if there is a shortcoming and that in fact, in the end, it turns out that the government's arguments are upheld and that there is no standing on the part of the LLC, and the counterclaim, which sounds as like an intentional tort, sovereign immunity is not waived, and all that is sorted out, then the government, by its very argument here, is saying that there are remedies that are available to us, and then we can seek sanctions.
So the answer to that question is no. I see that I'm over my time, but if I may briefly answer your question, the answer to that question is no. The fundamental finding in this disqualification order is that Mr. Pahulke is going to be a necessary witness. The non-party LLC continues to persist in that notion, and the Superior Court continues to refuse to entertain the government's plea for sovereign immunity. The government shouldn't even have to defend against these motions for disqualification and a counterclaim filed by a non-party because sovereign immunity protects it from that. And the Superior Court's diversion from that ordinary course demands extraordinary or interlocutory relief. In the alternative, if this court does find mootness, it should vacate the order to vacate the finding of Mr. Pahulke being a necessary witness, so at least the parties can start on a blank slate under the Munsingware Doctrine. But I firmly believe that the implications of this order are staggering and will chill prosecutorial conduct and attorney advocacy all across the board. And extraordinary relief is certainly warranted in this case. Thank you.
I have a question. Mr. Palu, assuming we don't act on the sovereign immunity issue, it goes back to the trial court. If then the trial court rules against the government, wouldn't that be the more appropriate time to bring interlocutory relief to the Supreme Court?
Interlocutory relief, maybe, but a petition for a writ of prohibition is certainly appropriate in an instance like this, where the Superior Court has failed and refused to entertain the government's sovereign immunity motion and entered an order at the request of a non-party which is a specific injury to the government's right not to be a defendant in court at all. We sued Teleguam Holdings Incorporated. A different party altogether showed up and filed a claim against us. We're entitled to have sovereign immunity determined before the LLC can proceed with any other issue in this case, including disqualification. And that was made clear too when the government offered to rest on its sovereign immunity briefs and proceed with that issue forthwith.
Thank you.
Thank you, Mr. Pauloon.
Thank you.
So at this time, this concludes our oral arguments. The court will take the matter under advisement, and we now stand adjourned. Thank you, counsels.
Thank you, counsel.
Thank you.
Thank you, Your Honors.
All right, goodbye.